good morning once again, ladies and gentlemen, and dear participants, for taking time out specifically on the Saturday, to understand what is next specifically for IBC. You heard Mr. Shukla talking about, the new changes specifically in the IBC and how they look at, the whole, world after the March. To begin with, obviously, I said that I have, two sessions. The first is specifically about from corporate data lanes, the good, the bad, and the ugly, and the second session is IBC at Crossroads, what next? To start with, I have this session from Corporate Data's Lens, the good, bad, and the ugly. And I have really remarkable speakers joining me here. And let me introduce them to you. My first speaker for this particular panel discussion is Mr. K.R. Sajikumar, the Joint Secretary, Ministry of Law and Justice. Mr. Kumar, welcome to this discussion.
Thank you very much, Amul, and all the participants and my esteemed panelists.
Great. So just to give some brief about Mr. Kumar, he is a Joint Secretary and Legislative Council, Government of India. Prior to this, he was an Executive Director at IBBI. He has been a legal expert at Ministry of Legal Affairs, Attorney General and Chambers. My next speaker is Mr. S. Ravi, insolvency professional, ex-chairman of BSE and former board member of various banks. Mr. Ravi, welcome to this discussion. So just to give you some more brief about Mr. Ravi is an IP insolvency professional and a practicing chartered accountant having over 31 years of experience. He's an associate member of Association of Certified Fraud Examiners, CECFE USA. He has specializes in forensic and insolvency assignments, finance and management, turnaround strategy, businesses valuations, brand and share valuations, audit and taxation. Mr. Ravi, glad to have you. My next speaker is Mr. Dinal Shah, insolvency professional. Mr. Shah, welcome to this discussion.
Thank you. Thank you, Amol.
So just to give some more brief about Mr. Shah, ladies and gentlemen, Mr. Shah is a partner and principal at Ernst & Young. He is a CA, chartered accountant obviously, and has handled several cases being an insolvency professional. He's experienced in litigation, mediation, mergers and acquisitions, corporate governance, intellectual property, and restructuring. My next speaker is Mr. Nishant Singh, partner in this law. Nishant, welcome to this discussion.
Thank you, Amol. Good morning, everyone.
Great. To just give some brief about Mr. Nishant. Nishant is admitted to practice law in India and New York, in the USA since 16 years. Nishant has worked a wide array of corporate transactions, including mergers, acquisitions, both domestic and cross-border, private equity, banking and finance, joint ventures and capital market transactions across multiple sectors. So really glad to have you gentlemen here. And to begin with, as I said, the topic of this discussion is from corporate debtors lens and the good, the bad, and the ugly. And I will start my first question with you, Mr. Sajid Kumar. Now you are part of the IBBI and now you are part of the Ministry of Law. The first question that everybody has today is, what after 25th of March? What is going to happen with IBC once the suspension is lifted?
Yes, everybody thought IBC and the whole of IBC ecosystem is going to be in crossroads, right? That is the theme also suggests that the regime has already undergone a lot of stress. In fact, like the stressed market, the IBC ecosystem itself has undergone stress because the regime was new, the processes were new, the stakeholders were new, the regulator was new, the NCLTs were new, the IPs were new, the IPAs were new, all of us were new. In fact, we started the journey from nowhere. We never had this kind of a law in the past. We had the provincial and the presidency acts of 1909 and 1920 pre-independence. Those legislations were not catering to the needs of the people, the needs of the stakeholders. They were not dealing with anything that relates to business. They were all individualistic bankruptcy proceedings. And bankruptcy or insolvency, as it was called, was supposed to be kind of a criminal thing. It is like an offense. It was too offensive, and that kind of social stigma was attached to bankruptcy or insolvency, as it was called then. But then we opened up the market in the 90s. We started doing a lot of business. Of course, when we started doing business, there was the need of new regimes. We tried and tested many things, starting from DRT, this, that, the company law board, many things we tried, the debt recovery tribunal, and finally we thought these were not sufficient and we need a new dispensation. And then when we started again, we were encountering problems, right? As I said, because of the novelty in it, we were all learning. All of us, the regulator, the government, all the stakeholders, even the parliament was also experimenting this piece of a legislation. And we all learned from our experience. Of course, we had experience of many other countries and our own experience in the past in our country. But then this was a new experience. Now, the COVID-19, of course, put a little halt to the whole of the processes because we had to suspend filing of applications as a temporary measure. It's not a permanent measure. That was the need of that hour. Otherwise, we would have been bringing many companies into insolvency. Pushing too many companies into insolvency was not a good idea because the economy was in peril. So that was a good decision at that particular point of time, though it was provided by the parliament in the law that it would be available only for a year, maximum 1 year. And in short duration, government was again trying and extending it from time to time. And finally, this is the last phase of the suspension. There is no indication either from the government or from the parliament or any request from any of the stakeholders to continue this suspension. So I think we are not going for any more suspension. The gates are going to be open from the 25th of March 2021, and we are again going to witness another flood of applications, maybe another challenges to the IBC ecosystem. But I'm sure the system is now robust, and we have learned from our experience. We have sufficient learning now all these years. I think we will be able to deal with the challenges again, and we are not going to any crossroads at all.
Very, very interesting. I think that's a remarkable view, Mr. Kumar. I think not only you give the description and the introduction about the IBC and how you started, but the more important news for us specifically, on this particular platform is, there is not going to be any more, pending status, or there is no, what you can say, any suggestion from the industry, to continue with the suspension, and the gates will be open in your words. But, when we understand the gates will be open, there will be a lot of, what you can say, surge in the cases. Already there are thousands of cases pending, and after specifically this 1 year, there will be number of cases. So I would like to ask the other panelists only one common question, and they can, answer this question with their own backgrounds. And my question to you is, what are the challenges that you are going to face now, because the IBC was not working for last 1 year, and there will be deluge of the cases going ahead?
Samol, before I come to this specific question, one comment on what Mr. Saji Kumar said earlier, is I am a part of the entire journey from 1st December 16 till today.
Right.
And coincidentally, I would not use unfortunately, but fortunately, I was the first IP of the country in Innovative Industries Limited, which has traveled between NCLT and Supreme Court 4 times. And right now I am a liquidator, performing my role as a liquidator of Innovative. And I must admit that the IBBI as a regulator, the NCLT, the Supreme Court, insolvency professionals, bankers, lawyers, all stakeholders have played that very fantastic role in these 4 years' time. And I would not have believed that, like I do practice on tax, but in tax cases, Supreme Court takes 5 years, 10 years, 15 years. In an IBC related cases, Supreme Court takes less than 6 months' time to dispose of the matters. And one of the fantastic judgments which the NCLT, NCLAT, and Supreme Court has delivered in last 4 years. And one of the important point which the law has settled is that principles of maximization of value and going concern has been blessed by the judiciary. And that was the intent of the entire IBC.
Okay.
Coming to your question on post 25th March 21, I agree that there will be there will be many cases being filed in NCLT. The only thing which we need to improve upon is the process and the timeline and the infrastructure at NCLT so that the cases are disposed of in a reasonable period of time. Though law mandates 270 days or 330 days, but we know in practice that these timelines are not maintained because of delays, because of number of litigation, different level of time. And therefore, the regulators and the judiciary both will have to work in tandem so that the cases are disposed of in a reasonable period of time and the objectives of the going concern and maximization of value is achieved.
Noted that, Mr. Shah. Now coming back to Mr. Singh, Nishant, you have been, working with NCLTs, and you must have a lot of, debtors and creditors in your, bouquet as your clients. What kind of challenges are you going to see after March 25th?
Sure, I think this is the question which is kind of teasing everyone. What's going to happen after 25th March? Will there be deluge of cases? Will lenders go easy? Still try to do resolution of the asset outside NCLT? And I think this last 1 year has given people a lot of thinking time, and we've been seeing many cases outside NCLT where lenders are doing one-time restructuring under the June 7th circular. So lenders are also thinking about what are the other effective means of resolution other than NCLT, because as much as there's been a great effort by the courts, and I totally endorse what Mr. Shah and Mr. Kumar said, I think holistically government with their fast pace of even amendments whenever there was a need. I haven't seen that in my career of more than 20 years. When there's a need, the government actually has come out with ordinances, they have come out with amendments to the legislation, and it has really showed up the confidence of the industry in the stress asset resolution. However, the way I'm seeing after 25th of March, it's been a period of 1 year, and more specifically, how COVID as a crisis has battered businesses. This is going to be a critical point because there's not going to be any protection anymore. The lenders will have to also see from a very realistic point of view how they're going to carry forward. So we will face a challenge because there will be disproportionate number of cases coming to the shore of the courts, and the courts will have to actually think through how to increase the capacity, how to resolve them in the time period of 333 days, though Supreme Court said that can't be the final thing. There could be exceptions to it, but at the same time, when any corporate debtor goes into bankruptcy, it's like a melting ice cube, right? You need to preserve the value. And as Mr. Shah pointed out, the core philosophy of the IBC is to maximize value. And if we are not able to maximize value by giving the corporate debtor that protection, that is very critical. So if you look at just in terms of how the IBC process moves, at the first stage, whether you file Section 7 or any other bankruptcy application, there is a process of admission. Only after the process of admission, the court will give any kind of protection against any kind of litigation against the corporate debtor or any recovery against the corporate debtor. And that process may take 2 to 3 months. So I think the first and foremost question is there has to be a process to make sure when the ban is lifted and there is a flood of these cases, can we prioritize the admission process so that the corporate debtor who need immediate protection, they get that protection and the process is jump started. Later on, yes, there is a significant beef up of our infrastructure which is needed.
Right.
But the initial process is going to set the tone, because if there are many cases which are coming to the court and the lenders are trying to recover money, and when I'm saying lender, they are not only financial creditors, we are looking at operation creditors, and multiple litigations are going on in various forum, and that's where IBC becomes a unified platform where if a corporate debtor goes, either lender files an application or you go through voluntary bankruptcy proceedings, you get the protection from the court. You get that breathing space to restructure your business and come out with a resolution plan.
Right.
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 And that's the limited point I had when I filed that application. There is a process in the court which takes typically, in good old days, even before COVID-19, it was taking around anywhere from 1 month to 3 months. And I don't know what is the impact of that process. If I can't get through the admission, then it will certainly impact, and it will decimate the value rather than maximize the value which the code intends.
True. I think few of them are really valid points, Nishant, and you mentioned about strengthening the processes, which is really valid. And I can see some of the questions about the admission and the process is also asked by the attendees here. I will obviously take questions as and when we have some time here while the discussion is going on. But I will urge participants to shoot their questions as many as possible, and we'll try to get it answered. So, Mr. Ravi, we are trying to understand the challenges that you are going to face, specifically in IP part or something like that. And, I would like your views on that.
IBC itself has gone through many challenges.
Right.
Home buyers, then corporate guarantee. Then we had the bidding process, which there was no earnest money put across. So there were many challenges which IBC has gone through in this whole journey from 2016. And there is a lot of challenge still that continues. And I think from an IP's perspective, the most important aspect is the information. So let us look at a borrower who has been borrowing money for 30 years. He has gone through consortium lending, he has gone to multiple lending, he has given his brand and various other forms of security that has been coming in and have all pooled in. And then there are operational creditors, and there are this whole loss cost of COC. So to control all this and get the right information is a big challenge in my view, especially in large cases. And that's why these challenges are taking place. Because one borrower could have gone through CDR, SDR, and all that. And the various terms and conditions that come across with that, finally, the crystallized balance comes in some form, finally. But what happens is, when you pool in the assets, there can be a person, a lender who can feel shortchanged, and they go and appeal. And the IP does not have a complete optics because the time is so short, and rightfully so. So the information base that the IP has is very limited or reasonably limited. So I would urge, because it's a question of information technology being giving a lot of prominence. Why can't we have more information, complete information of everything, right from day one? Why don't we have a system where everything is collected and given to the IP in a very easy manner? The second challenge, which is also there, which the IP faces, is the preparation of the COC. A very junior person comes to COC and they say, okay, next time we will see, we'll go back to our head office, we'll see we don't have the powers. So they don't have a decision making power. Now, like the board portals, you can have portals for the COC where you can put all your comments in one place and the IP can use that. So I think there are even these are the type of challenges that the IP faces: information, and second, the COC members' awareness. A branch manager is not even aware. Then the third challenge comes in is the state government and commercial law department, erstwhile sales tax department, which puts a claim. All this is unnecessarily scaled up, debated, and put across to a higher court. Why? So I think very clearly we should dismiss all these frivolous cases because we are already loaded with so much infrastructure challenges. I think we should have a very automated method of disposing of all these cases which are not relevant and which are beyond the code, and the code is clearly defining the sort of rights of every lender or every person who has a stake. So, for example, a tax authority, it's very clear.
True.
So I think this is where the whole thing can move to the next generation. And I feel that it is a very important aspect which we must focus. get the right information, get the right decision making.
True.
And I was just hearing Mr. Singh, the delay which is costing and which is creating erosion of value. Why does it happen? Because of all these little bit of ambiguities that exist. So I think we need to move to the next level.
Yes, Mr. Ravi. I think very, very valid points. But on the other side, even we speak to those people, those who are actually dealing with this also have this argument that IBC is obviously a fantastic law which nobody disagrees with, but obviously it's also new, and the government and everybody, all the stakeholders are trying its best to strengthen it. And we are trying to discuss here more about how we can strengthen it and what is the good, bad, ugly of it. So, Mr. Kumar, you heard, all the speakers, and I'm also receiving some questions from the participants. So, adjoining to what Mr. Ravi, Mr. Singh said, I will, shoot this question to you, and it will be really great if you could answer, compiling all, these thoughts. So, the question this is asked by Mr. Anil Agarwal, and the question is: delay in admission of case for resolution by NCLT has resulted in defaulters doing away with their assets and literally exhausting all value to be recovered, needs necessary changes in IBC. And secondly, fees to most of the IRP or RP remains an unrecovered. And this is the most unfortunate and embarrassing issue and needs to be addressing by IBC to protect IRP and RP financially. So, Mr. Kumar.
This is a concern not only to the stakeholders, I mean IPs and the creditors. It's a concern even for the regulator, the delay in the admission process. When we started this process, we thought the NCLTs will be admitting the application sooner than later, once the application is defective free and it reaches the bench. In the court, NCLT is also like a court. You need to file the application, and the applications will be scrutinized by the registry. And if there are any defects in the application in terms of payment of fees or attaching documents or whatever, the application will be kept as defective, and the applicant has to cure the defects. And there is some kind of a delay that would happen. And then once the delay, the defect is cured and the application is ready to be taken to the bench, then the bench is taking time even to list the application, right? And then once the application is listed, again, there will be multiple hearings before an application is actually admitted. So the delay is manifold. It is not just delay on the part of the bench alone. What stakeholders have to ensure that the applications that are filed are defect free, right? The registry should not have a kind of an excuse that there was defect and then it was pending, for curing the defects. That is one particular thing. If you take the case of an NCLT bench which is sitting on the matter of admission, it is something that is very serious. If there are no reasons, unnecessarily an application should not be pending admission for a long time. But if you analyze the law as it stands today, Section 7, if you take Section 7, subsection 4, the NCLT has to ensure that there exists a default. So only if there is a default that is in existence that the NCLT needs to admit the application, right? And now consider the effects of admission of an application to trigger insolvency. Once the application is admitted, the erstwhile director or promoter is going to be out of that business unless he is eligible to take back his chair through legal means, right? So 29A, if his position is hit by 29A, he will not be able to get back his business. So this involves actually greater constitutional challenge also. You are ousting a person from his right of doing business. It's his fundamental right. Of course, this is subject to reasonable restrictions. There is absolutely no doubt about it. But the authority, the quasi-judicial authority that admits the application, which has this far-reaching consequence, has to ensure that there exists a default. For that, it is not provided under the IBC how they have to deal with it, but under the NCLT rules, there are provisions like any other tribunal how they need to deal with an application. So they may have to give opportunity to the corporate debtor to say that, of course, there is no default and the application cannot be admitted. So that process of ensuring the existence of a default takes little time. I think there is a legal point in this. Without proper application of mind, an NCLT should not admit an application. At the same time, we can do many things to to overcome this challenge. If we have as Mr. Ravi said, we can enable IT system in the application scrutiny. If there is a, now that the applications are I mean typed, written, documents are attached, and the scanned copy is uploaded on the website of the NCLT. I mean, without this kind of uploading, why can't we directly file an application electronically, on a portal, and then like we apply for a passport or a visa? I mean, there can be a portal which is user friendly. You file the application, you attach all the documents, and once the application is defect free, we will be able to know that your application is ready to be uploaded. Then click it, and then you can avoid the defect delay in the application going in defect. And once the application is taken on file, accepted by the registry, it's an administrative kind of a job. Then the NCLT member get an alert that there is an application on your bench which has been taken on file defect free, and then let the time of NCLT judge, the member starts, then let him dispose it off. I mean, there should be a user-friendly online artificial intelligence enabled system to file applications. Then we will be able to avoid many such delays. And otherwise, the physical application, and then in the earlier times, of course, even today, who is coming before the NCLT to defend the corporate debtor, or for that matter, any stakeholder? The best legal luminaries, the best brains are coming, and they will have 101 objections. I'm not blaming them, because that is their job. The services rendered by the best brains I really appreciate, because the best legal brains in this country and the judiciary, they are responsible for giving a lot of clarity in the law now, because that every section was challenged. So I think we can think of some kind of an IT enabled system for an automated admission system.
Okay, so just let me quickly ask you, Mr. Kumar, is the government, is IBBI and also the Ministry of Law of Justice working on this particular aspect electronically? If yes, how long will it take to get ready?
There are thoughts in the government circles, in this regard. Even the Niti Aayog is thinking of some kind of a mechanism to ease out the NCLT process, and there is another measure that we can adopt, alternative dispute resolution mechanism even in insolvency applications.
Right.
It should not be restricted to other cases alone.
True.
There is better scope, better chance of conciliation and mediation in insolvency applications, right after filing the application and before admission. The stakeholders should be in a position to get some opportunity to rethink, to negotiate, come to a negotiation table, and then settle the dispute. And without the application being admitted, they can come out of the NCLT system, and many applications can be settled like this. ODR,
Right.
online dispute resolution system, that is another innovation which is being talked about. That will also be a solution for this kind of delay.
Thank you, Mr. Kumar. And Mr. Singh, I will come to you. My question to you is very specific. We understood and we spoke about the changes about the process and the admission. But considering the background of IBC, which is there since now 4 5 years, obviously we can exclude last 1 year. What is the success ratio? And what actually goes wrong specifically between the debtors, the creditors, at the NCLT in terms of resolving the case?
I guess there is no one clear answer what goes wrong. There are multiple players when a corporate debtor actually goes into insolvency. So as Mr. Kumar alluded to, you have the promoter who's going to fight really hard because you're restricting his fundamental right to do business. And this has been already challenged before the Supreme Court, and Supreme Court said that Section 29A is constitutionally valid. However, under Section 12A of the IBC, there is a provision which says if the promoter wants to do settlement with the lender, then the threshold is 90% of the lender need to agree, and you can still withdraw the application. And if you see, this is the major cause actually where even the largest bankruptcy cases got dragged. So if you look at SR Steel, it got dragged because promoter kept challenging. If you look at the latest example right now, Bhushan Power, again, major challenges. There is another case called ACCIL Auto where I'm involved. Again, promoter has been filing litigation left, right, and center, appealing every decision. On top of it, promoter has gone to even different judicial forums. So gone to High Court in Punjab and Haryana and got a stay on the proceeding. Finally, NCLAT is saying that Punjab and Haryana couldn't have actually interfered. We have very peculiar tribunal process here, so the Supreme Court has to finally intervene because high courts are also constitutional courts, and if they are taking a decision in their constitutional jurisdiction of section Article 226, then this the Supreme Court has to intervene. So fundamentally, I would say Section 29A has been a great source of friction. And I believe I practiced in the US for 7 years. I'm qualified to practice in New York. I've done bankruptcy matters there. I'm actually involved in cross-border insolvency matters. Section 29A is very peculiar to India. And I do understand, as in we have history of corporate fraud, but you pick up any country where there is no history of corporate fraud. Ours is not a peculiar country. Okay. And in that sense, after doing forensic, if you don't have any evidence that promoter has indulged in any bad doing, because there could be a bad economic cycle. You look at COVID. Now, if COVID has actually battered your business, and as a promoter, you would like to get a second chance, you can't say that you will not get that second chance. As in, promoter did not default on the debt intentionally or taken money out of the business to get punished in this way, right? So if I'm the promoter and then if my business gets into IBC for no real fault of mine, then I'm going to fight very, very hard. And the second side of the equation is obviously now that is settled to a large extent, conflict between the financial creditor and the operational creditor, and Supreme Court has said that operational creditors are not at par with the financial creditor. Nonetheless, again, I think it is not fair to some extent that operational creditors who keep the company as a going concern do not get anything, and you will have to do the liquidation value analysis to see where they stand. So there's a bit of a problem there. And then thereafter, yeah, we have multiple challenges. I think the time won't be enough, and I don't want to drag on, but
no, but I think you touched upon two important points, Mr. Singh, on that part. And, I will bring you here, Mr. Ravi, and, would like you to explain more about the spectrum called IP. There is often the complaint which is made by the, many parties that they charge heavily. Okay. And there are a lot of issues with that. Could you just decode this aspect here for the participants?
So there are various slabs of payment, one who charge very heavily and one who go through various quotations with various banks and end up getting doing the work at a very cheap cost. So there is this also this big thing that the big four are backed by a lot of team,
Right.
and there is a cost there also. And I'm not playing this big four versus others, but what I'm trying to say, the high end IPs, and there are these IPs who go through various quotations and finally end up not getting too much, and the responsibility is equal. Let me tell you, it's very equal. And also we must understand that the success of a process is finally where is the resolution
Huh.
and where is the recovery and where is the liquidation value coming to.
Right.
Either of the three. And I think it's very, very important to benchmark an IP success by what the person has achieved.
Yes.
And I think there should be a reward mechanism somewhere. Is there, of course, but
Yes.
but you know, the per month cost at some places is very high, and there can be recovery which is far lower, whereas a smaller IP, a person who's being less paid can recover far better. So I think here the economics or the way it will settle is success will settle everything. So it's very early days now. So, and you know, highly paid IPs who don't deliver means I know of IPs who have just billed during COVID, a very
Right.
high cost. Employees have not got the payment. Employees who worked very hard, who run the company, they have not got paid, and those IPs have still billed very heavily.
Right.
So there are instances. I've seen IPs who have sacrificed also, who said, okay, I can't give the employees this much, and so I will also take a cut. So I think this is a very, very big moral hazard. And I think
Exactly.
this aspect needs to be actually introspected. I'm sorry, I'm making a very strong point, but I think at the end of it, what we want a good liquidation value or a good resolution plan.
Exactly.
And the success is not based on the fees, but on the type of work the person has done. And I think there should be a mechanism to benchmark IPs at some point of time, because I have seen cases where IPs are hugely paid, but the liquidation value is nothing, absolutely nothing, because of various reasons. Could be not their fault, but then we should see what are we giving back, because we owe it to the people who have lent money to give them something. And I think this is a big
Exactly.
moral hazard, and we all see it day in and day out, and there is a lot of discussion around it, and I'm not opinionated about it. And we see, as far as I am concerned, we take cases which we can solve it, where we can take it to the terminal, where we can finish the whole process. And
I think the point that you spoke specifically about need to introspect, how the IPs are working is a really valid point, because I have been always hearing about it and many people are actually raising that point also. Mr. Shah, you're also, have your expertise specifically in this IP area. Do you echo what Mr. Ravi said? And also, if you could add, what is the best way or what is the best way to benchmark? How should IP, get rewarded if specifically on the case-to-case basis or a face-to-face basis?
So let me put it slightly differently than what my colleague panelist
Sure.
put it on the fees part.
Mhm.
So first is that the insolvency professional is ultimately putting his time and efforts. And for his time and efforts, he should get an appropriate remuneration. His remuneration has nothing to do with what could be the realizable value or what could be the liquidation value, because that is dependent upon the market factors and many other relevant factors of the corporate data. And therefore, linking up with the market or the realizable value on the resolution applicant or the liquidation value may not be that correct. Anyway, today under the IBBI rules, as far as the liquidation is concerned, the liquidator fees is linked to the amount which is realized by him. And that is also on a staggered payment, which is there under the IBBI rules. But as far as during the CIRP process, It's ultimately a mutual negotiation between the COC and the RP1. But to supplement what Mr. Ravi said, that yes, the insolvency professional role is very, very critical to run the operations of the corporate data and also to do a handholding with the COC to ultimately achieve an objective. And therefore, the good practices, knowledge of the business, understanding of the systems and processes of any corporate data, including managing the employees, suppliers,
Right.
vendors, customers,
Hmm.
and other stakeholders becomes very, very critical.
Hmm.
And therefore, in a lighter tone, when I am an auditor, I normally raise questions. But when I'm sitting on the other side, I'm more of a solution-oriented professional rather than only raising a question, because I will have many questions day in, day out as an IP professional.
True.
Number two, I would believe that the rules does allow, but there has to be a broader mind with the regulators and the stakeholders, that I cannot be an expert of everything. Like, for example, I will take an help of a lawyers, I will take the help of an expert for a particular business. Ultimately, my expertise is a financial acumen, my experience and my capability to run a business, but I may not know the every businesses which where I'm appointed as an IP, and therefore I should, the law does provide, as I said, but there has to be a broader mind with the COC and the regulators and other stakeholders to appoint the experts to maximize that value. And the last thing that I also agree, that the insolvency professional, since he is a very critical and a sensitive position in which he is, the highest standards of ethics and corporate governance and the integrity should be
Right.
followed by all insolvency professionals, because that is the paramount foundation of every insolvency professional in this journey.
Okay, so I will now take more questions from the participants because I could see, almost 300 participants are logged in, and more than 40 questions are already there. So I will shoot, questions, and Mr. Saji Kumar, you have most of the questions, being here from the government. So the immediate question that I think everybody has here is, what is the government's take on increasing the number of NCLT benches? I think this question has been coming since last 2-3 years actually, and now when we see the deluge or the floods of the cases which will come, this question becomes very important. So increasing number of NCLT benches and increasing number of judges, as this is the most important factor for the success of IBC. Your views, sir?
Yeah, increasing the number of judges is essential, especially when we have the floodgates, opened in couple of days' time. Um, the next batch of selection of NCLT members, the process had already begun. Because of COVID and there was suspension, I think the government did not go ahead with their appointments. I think it's a matter of time, more numbers of members and more benches to be opened. Of course, the government has already constituted an NCLT bench, other than in Delhi. There is one bench functioning in Chennai. In other parts of the country also in NCLTs, more members would be appointed. And that will be, I think, a watch and then, appointment thing that government may be adopting, because the government may like to see how many applications are being filed and how this is being increase the number of applications, and on the basis of that, I think more members will be appointed, and we need more members to deal with the challenges, especially when we have the personal guarantors to corporate debtors also implemented. uh, that is only a matter of time.
Okay, that's a valid point, and let's hope that happens very soon. There is another question, here. I understand that NCLT, NCLAT are under administrative control of the government. Can the government not direct them to decide on admissions in a time-bound manner, because chances of loss of value are enhanced once applications are filed? So, Mr. Kumar, you already answered this question about the electronic front and everything, but is there anything that you want to add here specifically?
But strictly speaking, it is not advisable,
Okay.
considering the separation of, powers.
Huh.
The executive should not direct the judiciary, NCLTs, NCLT, LAT, they're all quasi-judicial bodies. The government cannot direct them to dispose of an application within. We tried 330 days maximum, right? But what happened? Finally, Supreme Court said it is only directory; it's not mandatory. So our judiciary should have that their freedom to deal with applications, especially when there are serious consequences of admission of applications like this, like we have in IBC. So that may not work, but government has been taking up these matters whenever there are opportunities for government to come in to contact with them in some fora, some discussions, meetings like this. So government has been expressing its concern, and the judiciary also have accepted that this is something that we need to speed up. So there has been considerable interactions, and I think every stakeholder will continue to urge upon the tribunals to dispose of the applications as quickly as possible.
Okay, valid points. I will bring to you here, Mr. Singh, and specifically the question is about the resolution and the liquidation. What do you think is the success ratio in terms of resolution and liquidation? Because I always hear from the market that the liquidation is higher than the resolution. I don't think that is the ultimate goal which IBC had. IBC always focused on the resolution of the cases, but somehow we are heading towards the liquidations. So what is going wrong here? Do you want to just decode this topic?
Yeah, sure. So I think it's all about, first of all, whether there's a good liquidation value or not, right? There are different businesses which have good liquidation value, businesses which have hard assets have great liquidation value. And that's where sometimes, if you look at even distressed asset investors, they're more interested to pick up that slice of debt, and you may see faster resolution of those businesses. Businesses which do not have great hard assets, right? So let me give you an example. Let's say SRS Steel versus Jet Airways. Okay. SRS Steel obviously has a steel plant. If you were to replicate that asset, it's impossible kind of situation. It will cost you far more what you were getting actually in the resolution process. So that was a very sweet deal, as opposed to, let's say, Jet Airways, where there is no great liquidation value. There are a bunch of rights. Most of the planes are leased. And in that context, even if a distressed investor were to come and pick it up, finally, if for whatever reason the business were to run to the ground, then there is no good realizable value of that business. So fundamentally, then the difference comes: do you have a good management during the corporate insolvency resolution process to run the business and to keep the value intact, right? Because it's not like Jet Airways value could not have been kept intact. It could have been kept intact, right? If you were to do the funding, keep it running. So for example, the interim financing, that amendment which came and gave the supremacy, is very critical. And if lenders were in a position to provide interim financing in Jet Airways case, keep the airline running, perhaps the value could have been far different. And which is where I think the difference is how many matters can get resolved, because there has to be a viable resolution plan. And secondly, how many matters which are not able to get resolved within a certain timeline, and they're finally getting into liquidation. Right. Another example I can give it to you is of EPC construction firms. So when they have construction contracts, that's the only asset they have. They don't have hard assets. And you really need seasoned people who are in the management to run that business. And there is an inherent conflict, which I pointed out. Once the business goes into insolvency, the business owner is typically not having any interest if it's admitted, because he's barred from actually owning it again, right? And the current management also loses interest. And then you have IP to say that, IP will run the business. And I find that to be very daunting, because I understand a single man may be supported by all professionals, lawyers and consulting firms, it's very difficult to run business all of a sudden if you don't have continuity of the management. So though the IBC provides that the board of directors would be suspended, IP will take over, but there should be some provision, some incentive for the current management to continue to keep the business running. And that's where dissipation of asset happens. And finally, we land in a situation where we don't have more resolution, rather more assets are heading to liquidation.
True, true. That's right, Mr. Singh. I think valid points. Mr. Dinal Shah, my question to you is specifically about the IP. This is asked by a participant. Obviously, we discussed first part where the flood of the cases will be there, so the question belongs to that. So there may be flooding of cases. How's IP can handle such flood? However, to get this admitted may take some time. How do you see after 5 to 6 months from now?
So my view is that there are a good number of insolvency professionals today registered with IBBI, almost 1800, 1900 plus. And they should be able to take over irrespective of the number of cases which are being filed. The only thing is that they need to develop their professional skills and capabilities. What Nishant also said about is capability to run a business. And I think that development of a skill and knowledge as a professional is very critical. But I would believe that irrespective of number of cases, there are sufficient IPs. The government has yet not introduced the national insolvency exam. The still limited insolvency exam is there on the statute with a minimum of 10 years of experience. But I would believe that 10 years of experience to run a small to mid-size to large business is a reasonable period of experience for anybody. Amol, just one comment on what earlier Nishant said about liquidation and death. So one of the challenge which I have seen as an IP is deriving the correct liquidation value, though it is being done by the registered valuer with all expertise and knowledge and the rules of the valuation standards of the Institute of Chartered Accountants and the overseas. But the challenge is availability of a sufficient information, particularly for the joint venture, associate investment, subsidiary investment, certain advances, debtors. And that is one practical challenge, that whether the valuation done for a liquidation value is actually a correct liquidation or a realizable value. Because that sometimes becomes a benchmark for the COC to discuss and negotiate with the potential resolution applicant. And sometimes though rules does provide that if you have more than a substantial variation between the two valuation, you go to a third valuation. So rules have sufficient protection, but I think the availability information is one of the challenge for the valuer and the insolvency professional.
Okay, I think you touched a very important point, Mr. Shah. I will, try to, cover that in my last question. But Mr. Ravi, I have a question specifically about the resolution. Mr. Shukla was also here some time back, and in his speech, he spoke about, the parties are shying away from making plans of credible resolutions, right? Do you want to add what actually goes wrong? Why the parties are shying away from making credible resolution plans?
So, as I mentioned earlier, the biggest challenge is the COC. So you have to take a decision. When you have to take a resolution plan, you've got to take a decision. And taking a decision means you have to have an empowered person to take a decision. You can't, and the timelines are so stringent, and they are very fast. And you can hold as many COCs, but the point is are the members of the COC sort of tuned in with their head office, with their corporate office, and are they taking the decision? Because every lender has a different, somebody has given money under consortium, somebody has given money under multiple banking. So everybody's expectation is also different. We must understand COC is a bunch of people whose expectation may be very different. But getting them together is IP's biggest challenge. But more important, the cooperation of the COC and is very, very, very important for any resolution plan, because they have to take a decision, and any decision they take, they have to stick by it. And of course, there is a percentage, all that is fine. But the most important thing is the speed at which they take the decision. What are they prepared? Are they simulating enough before they send to IBC? Do they know what they want from them? What is it that they want? So I think that is very important. And the database. I was just Mr. Shah was talking of information. Do I know how many people are there who will be there in the H1? Suppose I'm in the paint business. So do I know all the players who may be interested in this business? So I think important is how we take a decision at point of time. And I think most banks have sent the junior most people to take decisions. And it's our experience means the people are not taking decisions and they let it go towards liquidation. And that is a challenge because I feel that there has to be a sense, and that's why I said information base is important.
I think data point is not only valid for IBC, for the for whole world now. That in fact all the companies are today run on the data. That is the primary oil that we have. So obviously that is an important factor here. So Mr. Kumar, I will come back to you with two more questions from the participants. I will take these two questions with you, quickly. So the one question is, time is the most important factor, and adherence of time is the most important factor by the stakeholders, including double A and NCLT, before anything else like maximization of value of resolution. Any point here, sir, specifically of the adherence of time, not only from NCLT, AAA, but all the parties involved? And second question is how to balance the IBC and PMLA. Both the IBC and the PMLA have non-obstruct clauses, and this leads to constant conflict between the two acts.
Let me first answer the last question.
Yes.
How do you resolve uh, the conflict, if at all, there is any between IBC and PMLA? I think the matter is almost settled because the purpose of PMLA is different, and the purpose of IBC is also different. And I mean, notwithstanding clause, you said non-obstante clause, it's only because the IBC is a later legislation, and later legislation, has to prevail over the other. But the purpose of the law, the objects are different. So there is absolutely no problem. PMLA is trying to, nab the persons who have indulged in, money laundering and, making illegal, gain, and using money made out of crime, for some purposes. So that is different from IBC's resolution process. But sometimes what happens is the PMLA cases affect the maximization of value, as we discussed before, because sometimes it may not be available for the CARP or liquidation. That is a hurdle. But many in litigations were there, and the matter is almost settled, that the IBC, that's the reason even section 32A was brought in by way of amendment, saying that there is no liability of the CD as such. The liability is only with the directors, and that we have other decisions also, the conflict with other legislation. Recently we have the case of section 138 of the Negotiable Instruments Act, right? So IBC has to prevail whenever there is an insolvency resolution process. The other question is time. And the major allegation or major concern by the stakeholders is that the time is not being scrupulously followed, not only by other stakeholders, but one of the main stakeholders, the NCLTs. The delay, the general delay in NCLT. I think this is an issue which is to be tackled sooner than later. Otherwise, the CD will be left with nothing after the admission happens 1 or 2 years of the filing of application. So that is not the intent and purport of this law. So a lot of interactions with them, the infrastructural changes in NCLTs are also happening, and sensitizing them to dispose of the applications. I think now this 1 year must have given them some time to dispose of the older cases, and hereafter when the applications will be admitted, they will be able to dispose of the applications quickly. And the IPs should also be very careful when they choose lawyers for their defense. There it is only natural that the opposite party would ask for time, and we should be in a position to resist it with tooth and nail whenever we get an opportunity before the NCLT. So all of us will have to be part of this process to minimize the time taken by NCLTs.
Right, Mr. Kumar. I want you to take one more question. In fact, this question is there by the participants. I think there is. So there was a lot of noise around prepack insolvency resolution. However, it seems it has been resolved now. But if you want to add more on that part, sir.
Pre-pack, we have been thinking about this pre-pack, module for a long time.
Correct.
There was a committee, everything is done. The matter was discussed in ILC. The process is also, there is consensus, with regard to that. I think maybe at the appropriate opportunity, pre-pack will become a reality, without loss of time. Because this is envisaged, without being, amending the law, even by way of a notification, it can be done. At least they should be done in the case of MSMEs. That is the thought process that is happening. So as the regulator, IBBA, I understand that they have done their job, completely, and it is being discussed at various levels before it is being brought into force.
Right, Mr. Kumar. I think we are just watching towards clock now. The time is just getting over. I don't know how the time has passed, but I will take one quick question, and maybe you can take just few seconds, all of you, just to wrap up. So, Mr. Singh, I will start with you. So the question is, I mean, we already discussed the changes, challenges, and expectations also. But if you want to add just 2-3 highlights or very, very important parts that IBBI, the Government of India, or all the stakeholders should do on an immediate basis to deal with more than 10,000 cases which are going to see, starting from next week, and the resolution at the earliest. What are those 2-3 highlights that you would like to see, Mr. Singh?
I think it's time for the pre-pack. In my view, if you just look at the US, UK, Europe, and the most mature market, pre-pack is the way to go if you want to really preserve the asset. And if you want to actually create a very effective remedy outside in a way of NCLT, though pre-pack will still have involvement of NCLT. That's number one. And if we are delaying it, in my view, it is just not going to pan out very good for the Indian market. Number one. Number two, foreign investors' participation in the distressed asset debt. So right now, if you look at the distressed asset fund around the globe, they are not able to participate. They have a limited ability either through ARC or as an FPI to actually participate in that debt. Recently, Reserve Bank of India allowed that defaulted NCDs of different corporates, they can be bought by foreign investors. So that's a very limited exception. However, we have massive debt, which is under default or going to come for default. And if foreign investors are not able to participate, we are actually blocking massive liquidity coming into the Indian market, which can really help to resolve these assets.
Right, Mr. Singh. Mr. Ravi, I will come to you. We would like to highlight 2-3 important points that you would like to see on an immediate basis.
A pre-pack is one absolute necessity.
Mhm.
And the second thing is, even the lenders have to be ready with their own database, because what really happens is once the process starts, then they start collecting all the information that is relevant to take a resolution. I think they should be more prepared, they should also evaluate what is the liquidation value they will get and what is it they will get in the pre-pack. And that is what is going to be very important. And the third is get the best investors in the sense of even the industry.
Right.
And that database needs to be there where you can pick up. So this company is going out, and this can be the person who can take this, because there are a lot of people who are interested, but we have to get to the right side and the right people. That is what is the three important things. And of course, the last but not the least, the cross-border, because this is going to get complicated as we go forward, and we are seeing that. So that needs to be sorted out. And fifth, regulatory sort of, for example, you take the issue of Tier 2 bonds of Lakshmi Vilas Bank and Yes Bank. We suddenly saw they being written off. I think regulatory absolute clarity is required in all these matters. I think these are my 5 takes as far as I'm concerned.
Thank you so much, ladies and gentlemen, for staying and tuning into this particular session. And thank you so much, Mr. Nishant Singh, Mr. Ravi, Mr. Shah, and Mr. Saji Kumar, for sharing your remarkable insights. I specifically did not talk about DFI or bad bank because I thought the focus should be specifically on what is going to happen next. And that's it from my side. Thank you so much. I would like to request participants to stay tuned for another session specifically on the IBC at Crossroads, what next, which is going to begin in just 2-3 minutes. But thank you so much, for being part of this session. Thank you so much.
Very good afternoon, ladies and gentlemen. It's indeed a great pleasure to be in the discussions on what next. We had been, and I've been listening with the rapt attention, the panelists in the earlier session on IBC at the Crossroad, on the issues, on the challenges, and what possibly needs to be done. We have, and we are now going to discussions on what next. What is next should be in terms of the law, in terms of the systems and the processes, in terms of capacity building of the stakeholders, in terms of the areas for a comprehensive insolvency package, which to begin with, when the IBC was evolved in 2016, was left and was left to be evolved based on the experience and the maturity the implementation of the IBC framework gains. And to discuss all these important aspects, we have a distinguished panelist who have vast experience in the industry, in the law and practice of the insolvency. Let me introduce them one by one. We have Mr. Bharava and Vakil. Mr. Vakil, welcome to you to these deliberations.
Yes, thank you.
Yeah, welcome. Mr. Vakil is one of the founding partners of AZB and Partners. He is amongst India's foremost restructuring, infrastructure and project finance attorneys. He has been the members of the government committee for drafting the report on pre-pack framework. Some of the questions those was raised by the audience, possibly he would be able to respond them more comprehensively. We have the next panelist is Mr. Shivram Bharava. Mr. Bharava, if I can tell you, out of the 45 questions that the 300 odd audience posed, about 20 to 25 were on the NCLT. So they would be keen on listening to you as to what happens at the NCLT, what can be improved, how can, if the NCLT can be made more efficient and efficacious. Ladies and gentlemen, Mr. Bharava is currently the registrar of NCLT. Prior to this, he was Joint Director as Competition Commission of India. And before that, he has been a Deputy Director at the Ministry of Defense. So he comes with a lot of experience of working at the regulators and also with the judicial authorities. We then have Mr. Kuldi Chawla. Mr. Kuldi Chawla is a former CFO of Puravankara Projects Limited and a management graduate from FMS Delhi University. He has a corporate experience of more than 35 years across many organizations like VLCC, Unitech, Redford Capital. So he brings with him the unique experience of real estate and also the financial services sector. Possibly, he has to deal with the interest of those home buyers who are left high and dry, I believe, so far. Mr. Bharava, are you there? Most welcome. We have then Mr. Shailendra Ajmera. He is a chartered accountant and an insolvency professions. He's been partner with EY, and he brings also with him a vast experience as a managing director, corporate banking at the Standard Chartered Bank. He, as an insolvency professional, has dealt with some of the large, medium, and into the diversified industry, the CIRP processes. So he has also unique experience of a finance expert, an insolvency professional, and also a corporate banker. Lastly, we would be joined in few minutes by Mr. Pawan Kumar. I will introduce to him once he joins us. Let me just take you through what is really, where are we today. The IBC as a regime faces twin challenges at the moment we are in. One is to manage the situation as to what happens after 24th March. So what next after 24th March? This is in terms of, the surge in the applications. If that at all takes place, there are two views. It might not be. We will discuss, deliberate that at a later stage. And if that happens, are we as an institution, as a law, as a stakeholders capable of handling and managing that? That's a very larger issue. We have more than 1.8 lakh crore of the assets which are sitting on the verge of moving into IBC, threatening to move into IBC if the IBC is lifted. IBC has been the main law for resolution of insolvencies and the professional. Any forward-looking economy, any forward-looking industry or business scenario would see that the IBC is a matter of last resort rather than the first legislation or the framework to address. It has to be alternative mechanisms rather than what we have been discussing all along, pre-pack as an alternative mechanism. I believe, as the speakers in the earlier session said, pre-pack has to be on the forefront of, and also together with the other mechanisms, on the forefront of resolution of the insolvency and the bankruptcy cases. We have all heard good about the IBC. No doubt, I don't think one need to roll out the statistics in terms of the number of cases resolved, the number of the time taken reduced, the extent to which the operational and financial creditors have been able to realize their dues. All said, good. 4 years, it has been a stellar performance of implementation of IBC regime, which in countries like USA took more than 15 to 20 years in order to stabilize. Now, there are issues, as I said, in the law of the IBC. It's delays, the disputes, which cost more, the adjudicating authority, the strengthening the adjudicating authority, how to use and infuse the IT and digitization to make the process efficient and efficacious, and also what needs to be done to improvise the processes and the system. So let me first come to you, Mr. Vakil. The law decides in the beginning itself how efficient and efficacious the regime would be. 4 years, as I said, we often say that the IBC mechanism has stabilized by now. The question is it really so? We have seen the IBC, the legal battles between the corporate debtors and the financial creditors, and the operational creditors, the competing bidders, the CVs and the bidders, and so on and so forth. They have gone to the beyond the NCLTs, taking the months and possibly years together in resolution, but it does help in stabilizing the law. We carried out at the IIPI a study as to how does the litigations are impacting the process of IBC. And to our utter surprise, every CIRP involves 3 litigations. The cost of is 18 lakhs per CIIP. And if you convert into the cases pending, it would come out to the hoping more than 540 crores. And it takes more than 113 days. So my question to you, to Mr. Vakil, is that when we look at the tomorrow, when we set the vision for the tomorrow and the day after, how do you feel? Is the law stabilized? And what are the aspects that the lawmakers should take into account so that the legal framework becomes far more fortified and, efficacious and efficient in the times to come? Mr. Vakil, over to you.
Thank you. Thank you so much for this wonderful opportunity, and also to all the audience members for listening in. So I think in fairness, of course, I should state upfront my bias, as I have been had the great privilege to be associated with this law from inception. But just 4 parameters I would like to bring out. One, the most important parameter, I believe, and I'm sure all the bankers will agree, is the credit culture change. In 4 short years, I think there has been a great behavioral and culture change thanks to IBC, because no human being likes to lose the company that they have set up. And I think now the attitude, the credit culture, because of IBC, has taken a dramatic change. The second one, coming to, maybe I'll start with the one you just talked about, the cost. So I have to say, cost-wise, actually, we are doing very, very well. I dare say probably we may be the most cost-efficient regime anywhere in the world, because these are all figures from IBBI. Prior to IBC, I think it was costing us approximately 9%. And now the cost has come close to 1%. So you can see that dramatic reduction from 9 to 1. And I dare say there'll be no country that has less than 1%. Whether it's, of course, US must be very high. But even if you look at Singapore or any of the jurisdictions, I doubt that they will do better than us. The other 2 parameters, quickly in fairness, to complete the report card, is recovery. Recovery before IBC was 22%. Now it is about 45%. So it has doubled in 4 years. But are we best in class in the world? No. The best jurisdictions are in the 80s. Singapore, Canada, etc. So we have got a lot of room for improvement, but it has only been 4 years. So I'm quite optimistic that we should get to at least 60-70% quite soon. And the last one, again, you touched upon, is time. So time also, I know a lot of us have been very frustrated. There's a lot of litigation and delays. Please remember, we started, a new law started with the 12 largest, most complicated case, thousands of crores. But in spite of that, I have not looked at it recently, but I think our average time taken is around 1 year. And there again, I'm very proud to say there is no country that has a faster regime. So again, you look at US, UK, Canada, Singapore, they are all in this 1 year band. So as long as we maintain, and NCLT and all our courts give the same priority and move with the same speed that they have done, and we keep to this 1 year, we are already as fast as the best. We should not let it slip. That's the only issue. So time, we have done well, despite some outliers, of course, but that is the case everywhere in the world. Cost, we have done fantastic. In recovery, which is very, very important, yes, we can do much, much better, and hopefully we will do much better.
Mr. Vakil, if I can interrupt, Our study of the entire, mechanism suggested that a lot of time is taken by the frivolous cases. Cases possibly which are not having a material bearing on the value maximization of the CD. But then we are a democratic country, and everyone has a right to approach to the the judicial authorities. But then, can the law be simplified, made more clear, and can that be maybe the legal profession as such, or maybe the judiciary can discourage the frivolous cases or the cases which would ultimately go to minimize or to reduce the value of the corporate data.
Haji, I agree with you fully. On all three, you will agree the law and the regulator has been very dynamic. They have made as many changes in a very fast manner, as you say, to bring further clarity. But I think both my profession, the lawyers, and I think NCLT and the courts, as you say, sometimes they are too patient. If there are frivolous cases, if there are issues like the famous issue about commercial wisdom has to be with COC, not with the tribunals, those should go much faster because clients have so much to lose. They use very famous, very top-known counsel, and then NCLT and the courts are too patient with the counsel. So I agree with you. Lawyers will always make arguments in favor of their client, but I think there needs to be a little more polite impatience from the tribunals and the courts, so that matters that are frivolous or well settled, we don't have to go on hearing the same arguments. We should move much faster.
Mr. Vakil, I fully, just to echoing your views and adding to what you said, possibly the legal profession is far more busier from the IBC cases than anyone else or anyone of the stakeholder. But then, I believe the stakeholders, including the IPs, the legal professions, should come and support or guide the regulator and the judicial authorities in what way this legal process can be streamlined, simplified, and the time taken of 130 days each case out of the 270 days is a phenomenal number. So how that can be reduced, and certainly we have a lot of responsibility in this regard, and to suggest to the government what should be the operating framework for pre-pack. So with that, let me come to the insolvency professionals, who are the another pillar of the IBC and who are responsible for taking the IBC to the next level. And let me come to Mr. Shailendra Ajmera. Mr. Ajmera, IPs have often been not satisfied. I've been seeing the questions that were posed for the earlier sessions. I think a large number of IPs raised the issues of the problems and the challenges that they are facing. They are not being paid, they are not being appointed in time, the COC is not responding. And also one of the panelists said that maybe IPs are not having that sense of responsibility which the law expects us to perform. Now, if you can be crisp and tell us as to, if you were to take IBC to the next level, the IP's interface with the COC and the other stakeholders to be hassle-free, what are the changes that you would like to bring in?
Thank you, Mr. Haldia. And first of all, I would like to wish Navroz Mubarak to Behram and all of us on the panel. Thank you, Behram, for taking time on Navroz. So many.
Thank you so much
for that. So thank you, Mr. Haldia. It's absolutely an appropriate question, but I can very crisply answer that each CRP case is very unique. Depending upon the size, depending upon the composition of the COC. But I could be very, very straightforward in saying that I myself have seen the involvement of the COC, the members who attend the COC from the banks. Earlier, there used to be a consistent issue in terms of what is the level which is being represented. So clearly, there is a change in terms of people who are coming from the banks who are better prepared. to participate in the COC, rather than coming to COC and waiting for their higher up authorities to take a call. So I think there is certainly a movement in terms of people coming well prepared, people represented at the higher ranks. But I think that is one aspect which as an RP, I feel that if they are better prepared and there is a scope of improvement there, if there is enough sort of authority in the COCs, things can move forward. So that's one aspect which I think can work. Second aspect, as an RP, I always practice is, as an RP, we also have a duty to absolutely keep the communication channel on with all the stakeholders. More often than not, RPs actually do not communicate as much as one would like with all the stakeholders. If the communication is timely, whether it's the lenders, whether it's the corporate debtors, employees, other stakeholders, I think we can achieve it much faster. That's point number two. Point number three, the way I look at it, and I'm just taking a question which is slightly off from what you asked, but I think going forward, it is going to be a volume versus value game. Give about a quarter or 2 quarters once the banks start using IBC as a platform. There I see if the volume is going to come through, then how the system, the whole infrastructure is going to behave is going to be a big challenge, because larger issues, larger cases were taking a huge amount of the total amount of NPAs, but to get to the same NPA, the number of cases which are going to come up is going to be huge. So quite obviously the efficiency of the RP, the efficiency of the judicial system, the efficiency of the banks to sort of put in, because quite often than not, the biggest stumbling block is, as all of us are aware, in the sort of admission of the case. So these are 2 or 3 things which will be very, very important as we move along. But certainly the efficiency of the COC, functioning of the COC, also in addition to the bankers, largely depends upon the RP in terms of the communication and what he wants to get out of the participants of the COC. Over to you.
Yeah, Mr. Ajmera, good that despite being an RP, you also touched upon the responsibility of the IP to ensure that the process is done through. I'll come to you later on when I have a question, when Mr. Pawan Kumar join us, as to, is the bad bank going to solve some of the problems that they are being faced by the COC? And secondly, is that the solution that you have given make us to believe that it is not only the law that is responsible for efficacious implementation, but also the stakeholder. The other issue is, which the RPs often face, and there were many questions in the earlier session, as to they are not, what they are being paid as a professional fee is not remunerative, considering the onerous responsibility and the time and effort they need to evolve, and also they are not being paid in time. At times they are asked to raise the resources from outside in order to fund their their own fees. So I will come to that later on. Please think about it, and do you have some workable mechanism? And we have been joined by Mr. Bharava. Mr. Bharava, welcome very much.
Oh, thank you, sir.
All the audience have been waiting for you for quite some time. They have many issues about the NCLT. How far, as if it is not the law, as if not it is not the different other stakeholders who also contribute to the delay and the cost of the process. They were asking the question as to how far we can make the NCLT respond to the challenge of 270 days and 330 days. Particularly the time taken in the into the admission, at times it runs into more than 700-800 days. Now when we are thinking in terms of IBC version 2, the IBC next, then possibly we need to address these issues. The issue about the infusion of IT and the digitization in the interface with the NCLT and in the processes of the NCLT. The finance minister talked about in the budget about the e-court. For the entire value chain. Now our just question is, and all of us are very eager to listen to you, if you can respond as to how are you positioning yourself to this challenge.
Yes.
We know the problem, we know the time taken earlier, but looking forward, how do you admit?
Okay, thank you, Mr. Aldia, and all other panelists also. So now I want to begin with this thing that when this assignment was given to the NCLT, that time we were hardly having 18 members. And we started with that. Somehow infrastructure, whether you can call it the IT and other, that was also very, this thing. But in the August 2019, we got around 53 members, and accordingly we constituted 28 courts throughout India. I'm just giving the highlights of the manpower and everything. So it is necessary to apprise all of you that what is the position of the members. So August 2019, strength of members was 53. Now it has been depleted to 40. It should be one. How it is hampering? Because there is a law that there should be 2 members and one technical, one judicial, and if one member is not on one station, then the proceedings affects one thing. Another thing, as far as the recruitment strengthening of the tribunal is concerned, we received our recruitment rule of the manpower in the last year in January itself. And after that, we all are the witness of this pandemic, and we could not pursue the much. However, during this period, what we tried, that is the IT or digitization. So as of now, throughout all our 15 benches, e-filing is complete. Today, all stakeholders can file their cases 24/7 to the NCLT, before the NCLT, anytime, any day. So that thing, I think, as far as the stakeholders are concerned, is a good thing. But now, as far as speeding up is concerned, let me apprise you all. Around 8,000 cases are still pending for admission also, and others are pending, going on after admission also. So one thing, I'm sure that all of you are aware of our cause list, daily cause lists, which are being published on our website. So during the last year, during this full year, 365 days, even from last March to this March, you see the efficiency has dropped. Why? It is because of the pandemic, and all proceedings we have switched over to the virtual one. So, the people were not habitual, the system was not accustomed to the virtual, so that was there. Still we tried our best to do that. Now, in fact, these are the factual things, but the main thing which I just now heard about from you all, that why the delay, why there was 180, 270, now 330, even that is not sufficient. Fine. See, one thing, when we analyze things with the economics or other, corporate parameters, legal or judicial thing, one thing, we must always remember this, that anything which is subject to the judicial scrutiny, then there is a mathematical type steps. You cannot jump the step. Here, Bharam Sahib is there, everything. So if you jump, the NCLT will jump, or say one application is not decided, maybe filed by anybody, then he will go to the appellate forum or somewhere, and then he will impede even the more time, for the more time. So that is the important thing, that how the applications, in fact, now the use over the regulator, I don't know under which this will fall, but if some regulation will be framed that no, the application of these things may be entertained, others may not be. For example, when the I remember now one It's not the quotation, but the one thing, when we were conducting a conference in the beginning of 2017, the Imperial Hotel, and Justice A.K. Sikri was, Honorable Justice A.K. Sikri was there, and our chairperson, Justice Mukhopadhyay, that time he told that after admission of the IBC cases, NCLT goes in Yog Nidra for 6 months. But that is, in fact, it's not so. The slowly people start awakening, and now, in fact, after the CIRP starts, the game starts. Number of applications from this corner, that corner, and the moot question of the admission remains the aside. And the NCLT, they cannot discard the applications.
Mr. Bharava,
Sir.
Mr. Bharava, this is a question that I also posed to Mr. Vakil. But my first quick observation is that while law is responding to the challenges in terms of 5 notifications and then 7 or 70 regulations in a 4-year time, but the infrastructure is not able to respond. Possibly we need to find ways and means. The second thing is that the ultimate objective of the law is the value maximization. That being the case, can the legal process, the judicial process, be not structured to deliver or to hear and deliver the justice in an expeditious manner, like a quasi-judicial cases, where the nuances or niceties of the law is often not that that follow. So this is the question before, and I will come to this question later on if Mr. Vakil is available. I will also request to respond to. But in the meantime, let me come to Mr. Kuldi Chawla. Mr. Chawla, as I said, you come from an industry which is possibly the, direct and a significant public interest of home buyers who have their hard-earned earnings put into the housing projects, and they are not able to finding a resolution. Now, coming from your background, tell us, there are cases resolved, a significant number of cases resolved of the real estate companies. But can you tell us the law as it stands today, the decisions that have come from the judiciary so far? Do you think, or what next needs to be done in order to see that the cases, particularly of the real estate, large real estate, are resolved expeditiously? And I will leave this question, later on to Mr. Shailendra Ajmera and Mr. Bharava. Can we have exclusive specialized benches for the large infrastructure projects or for the real estate? So that's the question. I'll come later on. But before then, also, Mr. Chawla, is the reverse insolvency a workable solution? If that be the case, why the IBBI is not taking recourse to that, that's despite this having got the approval of the judicial authorities? Mr. Chawla.
Thank you for that. Very warm welcome once again to everybody, including all the participants, and Navroz Mubarak, not just to Behram, but to all our brethren on this, and indeed around the country. I think just to set the context, what I'm trying to say, what I think is important is when you look at value maximization, I think there are 2 important tenets. One is time. Time is money. The second is value preservation or lack of value destroying. And I think in that context, Mr. Haldia, the point that you made subsequently, which is of separate benches, specific focus, subject matter experts, or indeed, to pick a phrase that Behram talked, and I love that phrase, Behram, which is, I think we need to move from polite impatience to rigorous implementation, almost ruthless, if I may take the liberty of using that phrase. But I think, to reiterate, we need to move fast. What do we need to do move fast is, first, we need clarity. The second thing we need is and along with clarity comes removal of all confusion. So I think there's going to be a deluge, of cases. And the fact is that whether big or small, each case needs small cases don't need less time compared to big cases. right? So if we are to achieve our goal, both in value terms and in terms of what we are setting out to do, we need not just the judiciary, we need everybody to move faster. We need them to move with clarity, and we need to have implementation, and we need to have settled cases. We can't have confusion. Now, as far as home buyers are concerned, I think, or whether you look at home buyers, you look at infra, or you look at consumers in general who are impacted by this, unless we have expertise, unless we have special courts, unless we have, a burning desire to do this 24/7, I don't think it's going to happen. Whilst I respect, the fact that we've done better compared to other countries, as a believer in India, I think we should set the standards. Why can't we be the best? Why do we need to have comparisons? The other aspect I think that's perhaps important to mention, and I alluded to this, is if we are to preserve value, then I think we need to have a parameter which says, along with the filing of an application, we need to have clarity on maintenance. Unless we have that money, people like Shailendra and our colleagues there will not, put, metal to the pedal. Let's be candid. They need money for the services they render. That has nothing to do with the value that they're helping preserve. So that is part one. Part two is that unless we have that, you will see much more liquidation, which is not necessarily a great thing, So we've got to have courses for horses. Back to you, sir.
Very well, very rightly said. We need to bring back our horses to the courses. So that's an excellent point. And we welcome Mr. Pawan Kumar. Mr. Pawan Kumar, welcome very much. And ladies and gentlemen, let me introduce and welcome Mr. Pawan Kumar. Mr. Pawan Kumar, you are most welcome, and please.
Thank you.
Turn on your mobile. Yes, I know you have been very busy since morning in your meetings, one after the another. So thank you very much for finding time. I know, Mr. Pawan Kumar, you are very important for this webinar because with you, you bring three perspectives. Perspective, you are a government officer of Indian Revenue Service of 1990 batch. You have worked in the Ministry of Corporate Affairs, which is the father, the ministry for the IBC, and you have worked as an executive director in the IBBI itself. So you have experience of government, you have experience of regulator, and finally, you are now a deputy managing director of IFCL, which is one of the largest infrastructure financing institution. And a lot of debate and discussions today as how the development financial institutions are going to take shape in the times to come. So I straightway shoot out a question to you, is that while you bring your three perspectives together and tell us in few sentences as to what next you think the IBC version should have, learning from the experiences and new initiatives that it should take. And secondly, after that, do you think the developmental financial institution or a bad bank are going to enhance the efficacy and efficiency of the insolvency and bankruptcy mechanisms? So these two questions. So with that, the floor is yours.
Thank you, Dr. Haldia. I think, thank you so much for your kind words. Our association actually goes back to more than 2 decades. When I started in the Ministry of Corporate Affairs, when we were implementing MCA 21. So that was the point, and you were helping the Institute of Chartered Accountants. So that's how our association go as a stakeholder. But more importantly, the three perspective, I think I served in the government. Then I went to the regulator, saw the life of executive director being in a regulatory regime. And now coming back to the being action again in the field. So I realized that collecting taxes is more important. One learning is then giving money, being a banker. It is a tough job now because you always fear 3 C's, always watching you. So in the present times, and giving funding, especially in the infrastructure sector, is fraught with all kinds of ifs and buts. So Kuldeep ji is here, so I won't like to say much because he can understand the plight of a banker as well from the perspective and the uncertainties the infrastructure sector faces, and more so the part of that, intrinsic part of that construction. I'm realizing, and coming from government, I realize that more of the problems are arising on account of policies which we in the government are, when sitting on the other side of the table, a large of it, part of it can be attributable to those kind of things. Of course, government is conscious, and now over a period of time, a lot of those policy iterations have been kind of corrected, whether it is NHAI or whether it is Ministry of Power or whether it is other government regulators. Now, coming to the theme of insolvency, I believe that the government was very proactive as far as the regulator. I think it is one of the finest regulator, IBBI, is there today in the market, which has been probably leading from the front in terms of implementing changes. And so was no different the response to in the wake of COVID-19 also. Whether it was increase in the threshold or putting a moratorium, it was all in consonance, and now moving to the stage 2 response, which is in line again with the global trends led by the whether World Bank or other developed economies, UK, US or Singapore. We are, whether it is, I think all the participants, and they are aware that government is working in tandem with the regulator to bring out the pre-pack and other for resolution of MSMEs and other sectors. So I think yes, it is all in the works, and a lot of work in progress has already been achieved. It is only when some part of the implementation issues are being examined very closely, so that once the particular mechanism is thrown in the market, it is well accepted by the market participants, and it is all those kind of, there is no need to go back a step, coming forward and going back. So I think that is what the government is conscious at present. And as a banker, I am also facing the same. When our NPA, we look at the size of a portion of our NPAs and go into the resolution. Now at least we are making sure that when my person attends the meeting, he attends the meeting of because we participate as a part of the consortium. So when my officers are attending the meeting, I have given clear-cut delegation that you are empowered to take quick decision. And if something is going beyond you, please put up, we will take a decision within 48 hours. So 48 hours is the outer limit within which we want to take the institution and be not a part of delay, but rather be a part of the facilitating in prompt resolution of cases. Again, I think when I was in IBBI, we were looking at it, and Mr. Bharava would agree with me that ramping up of capacity of the benches is something which is, I think all the panel members, including Mr. Ajmera, would agree that that is what is required as a earnestly in the quite quickest possible time. That is what is required. In fact, steps were taken in May and June, but still they have not been fructified in terms of clearances. So let's hope that we have those benches and members in place. The second is, yes, this idea, Secretary Corporate Affairs, that there is a time that not only the insolvency professionals also need to be fine-tuned to becoming a sectoral expert. Because an insolvency professional, some people we found that we did studies, we found some of the professionals have turned around real estate companies, some have turned around the hospitality industry companies, some have been a part of the steel industry, iron and steel. So let's make even an IPs and even some of the benches, like we have income tax appellate tribunals There are members who deal with only international tax disputes. So time has come that even for prompt or achieving more efficiency in the disposal of cases, the bench strength also needs to be augmented and made a kind of specialist along with a line of specialized insolvency professionals. I'll go down to that step. So I think with these words, Dr. Haldia, over to you so that we can mutually learn from each other.
Thank you, Mr. Pawan Kumar. I recall 20 years ago, we were possibly part of that first discussion that took place as to how they reform the insolvency or bankruptcy law in the country, and it has taken 20 years, the law to come in the shape.
I remember first advertisement for taking NCLT members was issued by me as Director MCA in 2005. And then we see the history, 2012 or 13, it actually came into being.
But Mr. Pawan Kumar, I know I like to emphasize the guiding spirit that the IBBI is following, and that you emphasize that we need to be outcome bound rather than the action bound. Now, the question that I posed to Mr. Bharava and also Mr. Vakil, if he's available, why can't we make the judicial process outcome bound rather than the process bound? We know we have to follow the principle of natural justice, fairness, but then there is something like quasi-judicial process. We in the process should not lose the value maximization objective of the IBC. So Mr. Bharava and Mr. Vakil and then Mr. Pawan Kumar, if you could just, it's a very important thing because if we need to take IBC to the next level.
First of all, one question that revamping of the benches, certainly it's a good suggestion, and we'll try to do that. In fact, if you people are closely observing the principal bench, right now we have divided days. For example, Monday, Tuesday is dealing with the certain cases and like this. So this is you can say an experiment type. So now the moment we'll get the members, certainly I think revamping of the benches will be agreed by the even my superiors, the president and other people also, and we will come with such thing. I hope so. Another thing, the technology part also, I am just want to apprise you all. So that besides the e-filing only, we have initiated the e-court, complete e-court, means paperless now, and including the judges also, everything, your dashboard, you can see where the case is pending, when it was filed, when it has been admitted, and how long it is going, how many applications are there. So what that thing we are doing, we have in fact completed the software, and now we are implementation stage, and I am sure that within 2-3 months you all will see that yes, there is some good thing. So transparency thing will be there, and disposal will also be will increase. But one thing will definitely in dire need of the members.
Yes, but Mr. Vakil, would you like to respond to the issue that I raised? Can we make the judicial process like a quasi-judicial, or the process considering the underlying objective of the IBC? Just in a few sentences, if you can. I know it's a difficult question, but then if possible, if you can answer.
Very, very difficult, and I think sadly, I'm not sure it can actually happen. We tried very hard, as you know. We put 330 days as a mandatory time limit, including judicial process. And you saw that even the finest judges in Supreme Court said that this is not mandatory, this is just suggestive. So to do anything more with the judges, I think it's a very difficult task. IBBI and MCA and all the drafters have done their very best. I think capacity is the crucial thing. You'll remember they doubled the capacity. I'm very sorry to hear today that it has gone down once again. I'm sure there are good reasons, but capacity And many of the speakers alluded to specialist benches. Let us at least start with special bench for IBC cases, because otherwise, as NCLT knows very well, they have given us a lot of priority. So the normal company law cases are suffering a lot. So I think a good start would be to have special benches for IBC. That will help a lot in every way.
You are right, but I believe other than the capacity building is also very important.
Yes.
Unless you
No
do
doubt.
that, you are not able to change the orientation, the approach, and the attitude to what is expected by the IBC. So let me come back to Mr. Shailendra Ajmera. The question that I asked you about the bad bank and the the development of financial institution. Quickly, if you can respond, is it going to help?
So certainly, I think the transfer of NPAs would happen based on some formulation, and there's not going to be any discretion as far as that is concerned. But I think from a process perspective, sir, very crisply, I think the unanimity amongst the OCC, the COC members is something which could be sorted. I mean, if it's all a single decision maker, once the assets are transferred to the new bad bank, then that could fasten the process. So certainly there is going to be a change, because right now to bring consensus among the COC members is one of the biggest times which RPs and the entire stakeholders have to spend on. So certainly if this was to happen, this will be a smoother process, and then it could move on to the asset management company for the turnaround and the O&M before they finally sell it. So certainly it will help.
Yeah, Pawanji, do you have any thoughts on this? Is it going to help? Is the bad bank per se going to solve the problem? It is the the old wine in the new bottle, or is really going to change the scenario?
1 minute answering your previous question, which I liked, outcome or process bound. Outcome, right. I have two suggestions in this. One, when I was in IBBI, we have a case where COC has already approved the resolution plan, but NCLT is taking 7 months or 8 months or 10 months, even in some cases, just to put their stamp of approval. If somehow those cases can be expedited in one, these are low-hanging fruits, what we call. So we become outcome kind of bound, and we can dispose of. Second suggestion is those cases which are pending for admission, simply they can, I think one can hear, because it's a quasi-judicial proceeding, but one need not pass a lengthy order unless you are laying down some principle of law. The judgment itself can be use of technology. You can make a computer type that after hearing both the parties' cases admitted or rejected, whatever. So that is, I think these are two things which can be done and implemented very quickly by using technology. The second part which Dr. Haldia asked me is regarding bad bank. Honestly, we are also grappling as a DFI, we are also grappling with this issue, what to do. But certainly, one thing is for sure, that unless the bad bank is given the power to restructure the assets in a professional way, in whatever way they want, because I hear some litigation is pending on the issue where our sectoral regulator has raised the issue, RBI, whether they can go and challenge the restructuring, because asset reconstruction companies are not been given the power to go for that. So unless, I think it would be improper for me to react unless we get a clear mandate as to what is going to be the role of ARCs, unless they are permitted by the RBI. So I would just stop short and will not dwell on this issue further.
No, I think you had given very valid suggestions. More than 20,000 applications for admission stage, and only 500 to 600 in a quarter are getting disposed of. So we can see what is the pipeline and what is the lengthy queue that is there. Now, Mr. Ajmera, you have been in the real estate industry and you are a finance man. Tell me, this reverse insolvency, the existing promoter allowed to take borrowings, and then going ahead with the project. And the another issue is whether the challenge of one project to many projects, whether insolvency only confined to one project, not the other projects, and the challenges between the holding company and the subsidiary company holding the lands and the holding company implementing, whether those issues have been resolved or those are yet to get a legal clarity or judicial clarity.
Yeah, thank you, sir. And my apologies. I know you did ask the question and I omitted to answer it. So I appreciate your asking me again. Let me put things in context. No, I mean, the short answer is no, I don't think those issues are resolved completely. I think there are some complexities. I think the complexities are largely to do with the nature of the real estate business, and therefore my earlier comment that I think we need some specialists, apart from the judicial side, we also need some specialist intervention on the sectoral side. As far as the question that you have raised about separation of the project from the rest of the business, I think the short answer is yes. The complexity is how to do it, because not all the lending very often is project specific. There might be more than one project. The end use may have been beyond the project in the pre-RERA kind of, framework. The third aspect that you have raised is about the issue of the promoter or the holding company wanting or agreeing to put some money into it. I think that is highly desirable. It shows alignment of interest. I think it is important to help ensure that at the end of the day, not just because real estate, has customers who, and this is the single largest purchase for them, so on and so forth, but also from a resolution issue. Finally, I think it is also important that, like I have said earlier, there are some assets that we should think about how to preserve, because at the end of the day, money might be one aspect, but we have to see that very often in real estate, because of appreciation and indeed sometimes because of other factors such as possible increase in buildable area, there might actually be a surplus. Apart from the fact that what the resolution really requires is a timely implementation and the collection of money. So very often, I think real estate lends itself to specific aspects along the lines that I have outlined earlier. I hope I have not left out any of the few questions that you had asked.
No, Mr. Chawla, you have very well addressed. In fact, you have emphasized the need that the law is not enough. The law is also need to allow the professional approach to be adopted, and then the mechanism or ecosystem should facilitate that professional approach on the ground. So you have highlighted very important point. Now we have almost come to an end. And
Sir, if allow, I want to comment on this low-hanging fruit comment of Pawan Kumarji. See, one thing, fine, NCLT might be taking after the submission of the resolution, but one thing, what is the reason? It should be analyzed, one thing, and most of the time, the moment the resolution plan comes, immediately after there is a several application from the unsuccessful bidders. Now, the onus goes to the RP. The RP should, in the 30 second, I am summing up that RP should dispose of all the bidders' application through a very speaking order. There should not be any scope to file an application before the NCLT. This is the most important thing. And if even after somebody says that the pleading or persuasion from the RP side should be there, that NCLT cannot keep pending. This is the most important thing. Commercial wisdom, forget of the commercial wisdom. Nobody is questioning commercial wisdom. It's a procedural wisdom, in fact.
No, you are right, Mr. Bharava. That is why it's so important that you are on this panel, because being a judicial authority, they are not able to, air their views and possibly what can be done better. to improve the process, and the other stakeholders have full freedom to air their views, and therefore NCLT is alone often under the review, if I not say scathing attack, and ignoring that other stakeholders have also to play their role to improve the efficacy. So with that, I have a couple of minutes, and so I would ask or request the panelists to what one or two points they would like to emphasize if the IBC has to be revamped for the tomorrow or the needs of tomorrow and the day after. And I would start with Pawan Kumarji, and if you share your wisdom on tomorrow.
I think tomorrow the biggest challenge which is going to come up is again what we are going to expect is probably a huge number of cases which may come up. And secondly, as banker, we are all awaiting the Supreme Court judgment to give clarity on the framework and the restructuring framework they had given the bankers. A kind of that decision, unless that comes, we don't have a way forward to actually what to do with the kind of delinquencies which are likely to be faced by the banking sector as a whole. So I think we expect that again, the judgment to provide us clarity, and thereafter we take this step. And that is going to be a big challenge for the IBC in the days to come. So I think we would wait for some more intellectual manthan after a quarter. We hope the Institute of Insolvency Professional takes a lead and comes forward then actually to see how it comes.
Certainly.
I think for the time being.
Certainly we will, we have taken up some of the research projects, and we will certainly get in touch with you to get your multiple perspective into that exercise. And Mr. Bharava, last word, anything, some thought that you have left? Of course, you have aired your thought process, but something more that you like to add?
Sir, 2-3 things. That the moment IRP is appointed, so there is a, some privilege applications started coming there only. And instead of the filing before the IRP, they are filing before the tribunal. So, the tribunal can't discard. But my mailbox is also full of that thing. So, my request to the IRPs, that they should hear, they should listen to the people. What is the, small things. And then maybe the employer side or maybe the other side, but they are, pondering the box of the NCLT, and we have to decide we cannot discard, in fact, straightway.
So, Mr. Bharava, at IIPI, we will certainly work on this and certainly would come out with some workable solution. Mr. Vakil, are you with us?
Yeah, thank you.
Thank you very much for being with us, because I know you are occupied in other things as well.
Thank you. No, in fact, I wanted to ask Mr. Bharava just, but take another opportunity, because as you say, it's very good to have him with us, that the delay in admission process, I know it's a huge backlog and we come back to the same issues, but if there is something we can do using the IU mechanism and more electronic or some kind of tweak in the law which he feels which will be helpful, so that the delay in the admission process is resolved. Besides that, I'm cautiously optimistic that the new pre-pack process which should come soon, that will help a lot, especially the MSME sector. And then the others you are well aware of, cross-border, group insolvency, personal insolvency, these are all on the cards. So picture abhi baki hai.
Definitely, sir. Definitely.
Mr. Vakil, my vision for version 2 is that IBC should be taken recourse to only when it is absolutely necessary and other measures are failed. So pre-pack is very important in that direction. Mr. Chawla?
So apart from pre-pack, value preservation, alignment of interest as far as the corporate debtors and indeed the resolution applicants are concerned, because capital is available, but capital will get scared very soon if it takes too long, becomes too complex, so on and so forth. So apart from that, clarity, speed, implementation. Thank you.
In the earlier session, Mr. Singh, one of the panelists, and Mr. Ravi pointed out that we need to create a market for the distressed assets. In UK, you have a market even for the junk products, junk instruments. We need to find in India, unless we are able to, we would continue to face the problems of resolution and resolution plan.
Sir, and if I may add very quickly, having been a former banker and spent more than half my life on that side of the table, the amount of capital that is ready and available, including global capital, domestic capital, is humongous. We need to provide that opportunity for this country to regain its glory on the global stage.
No, in a lighter sense, I have been telling for last many years that the tons of money is outside India waiting to come into India if we have a right ecosystem for stress assets. That's the challenge. Finally, Mr. Ajmera, the law, has an onerous responsibility on IPs. And other than the NCLTs, IPs are also, are being questioned, or they have been also asked to build capacity or respond. So do you have any last few words?
So, thank you, Dr. Haldia. I'm conscious of the time. I know we are absolutely at the end. I think Bharava covered pretty well in terms of the cross-border group insolvency, all the other ones. But I think one pertinent question going forward is what are the kind of insolvency cases which are going to come in? They are going to be the mid-market, which is actually a squeeze between the MSME and the larger corporate, which we've seen. I think I've been a banker myself, and I can also see what is the kind of resolution plans which are going to come for those squeezed kind of companies, which are neither MSMEs, not large corporates. I think one would have to relook the treatment of Section 29A, which exempts, the sort of a continued promoter to sort of bid. I think that is one thing which needs to be watched out, because MSME IBC is still some time away. I think the next road is going to be mid-market companies, and there is going to be not as many takers as one would have seen in the earlier avatar in terms of the phase one. And the treatment of Section 29A, the partial exemption, is something which I would really look forward to as to how that is addressed going forward.
Mr. Ajmera, the Section 29A doesn't debar the existing promoter if the existing promoter has behaved well as a borrower or as a promoter.
Yeah, absolutely.
So, but then you are right. You are right in the sense that what way we can ensure that an honest promoter can come forward and take over, but because otherwise every promoter is being looked as a suspect, and therefore in the public accountability system that we have, often they are not encouraged. They are not looked upon.
Absolutely. Well, I agree with you. The answer lies somewhere in between. Over to you, sir.
Yes. So thank you very much, ladies and gentlemen. It has been a great pleasure for me, at least that it has helped me with these distinguished panelists to think about tomorrow and day after about the IBC and how enriched their experience. Mr. Pawan Kumar, Mr. Shivram Bharava, and Mr. Vakil, Mr. Chawla, and Mr. Ajmera. I know how busy they are, and they have found out time even on Saturday to be with us. And I'm aware of more than 350 participants with us today. And I've never seen so many questions coming around. I hope we have been able to justify our role as a moderator by pulling together the questions and ask the panelists the theme and the substance of the substance on which the question have been asked. And in the end, I would express thanks to the ETCFO, which has been a torchbearer for the thinking process for the financial world and the economic area. And I only say that the IIPA is very happy to be associated with this exercise. We have been taking a number of initiatives in acting IBC as an enabler to the reform process. With that, thank you very much, ladies and gentlemen. I've indeed been greatly honored to be with you. Thank you very much.